Republic of Nigeria, Cap C-23 Laws of the Federation of Nigeria, 2004, to set time within which civil and criminal causes and matters are heard and determined at trial and appellate courts in order to eliminate unnecessary delay in justice administration and delivery, and for other related matters be read the second time. I so move, sir. Federal constituency, which is 18 and Saribum, Nsurubium Federal constituency, be heard. My name is Onofiok. Mr. Speaker, I am pleased for this opportunity to lead debate on this seminal constitutional proposal, which, when passed, would entirely change the face of justice in Nigeria for the good of all. It's more pleasing that this proposal is made in this particular legislative house, which is known to be pro-people and take people's stands and interventions, and also taking bold steps in line with our legislative agenda to bring about justice sector reform. Mr. Speaker, the background of the bill, dear members, the pace of justice delivery in Nigeria is alarmingly slow. In average, cases stay a minimum of 5 to 15 years before determination and judgment. The snail-like pace of justice delivery has caused great discomfort, inconveniences, and hopelessness to litigants, investors, citizens, and businesses. People only know the date they approach the court, but they do not know when their matters will get determined. The inability of our judicial system to deliver justice to the people within a reasonable time has occasioned great frustration on the part of the people and has caused them to resort to self-help, fast means of obtaining remedy and justice, Mr. Speaker. Mr. Speaker, slow justice delivery stands as a stumbling block to Nigeria's industrialization drive and foreign investment. Speedy justice delivery bolsters economic development by improving the enforceability of contracts, settlement of disputes, etc. It guarantees enforcement of fundamental rights, stabilizes the polity, and minimizes chaos, reduces resort to self-help, and boosts people's confidence in government. Mr. Speaker, permit me to say this. Some years back, honorable colleagues, elections petitions used to drag in court for several years before this hallowed house, in consonance with the Senate, took the bold step of limiting time within which election petitions and electoral matters should be determined. The single legislative decision expedited hearing and determination of election cases and has provided electoral justice to politicians and political parties. This bill seeks to, in a large scale, but in a similar manner, provide justice to the people by setting time within which matters can reasonably be determined in court. Mr. Speaker, to buttress this fact, we want to bring the stance of Mr. President of the Federal Republic of Nigeria in justice sector reform. At the first virtual annual general conference of the Nigerian Bar Association held this year, President Muhammadu Buhari, GCFR, the Commander-in-Chief and the President of the Federal Republic of Nigeria, represented by the Vice President, Professor Yemi Osibajo, suggested the need to limit the lifespan of matters in court. That shows the willpower and the political power from the executive. So the responsibility now lies with us, the lawmakers, to craft legislations so that we can give legislative backing to that policy direction that the executive has exemplified in the speech of Mr. President. If the two top powerful leaders of the country can find the need to have matters in court limited by time, how much more will common litigants who have no other avenue to turn to, but largely depend on the court for justice? So, Mr. Speaker, it is on the basis of this that this bill is being proposed. The bill seeks to amend Chapter 6, Part 4 of the Principal Act, that is the 1999 Constitution as amended, by inserting after the existing Section 287, a new Section 287A. This section sought to be included has 10 clauses. And one of the clauses, which is the only one that I'm going to point out here, Mr. Speaker, is that clause 1, which mandates every trial Superior Court of Record to deliver judgment on a matter before it within 270 days. That is a period of 9 months from the date of filing of the civil or criminal matter. And Mr. Speaker, electoral matters are, however, exempted by this clause, since such matters are specially regulated by other constitutional provisions. So, Mr. Speaker, the bone of this is that we have had so many of our people in criminal cases wasting away and leading occasion to the congestions of our courtrooms. So this bill seeks to congestion of our correctional centers. This bill seeks to decongest our correctional centers. This bill seeks to decongest the cost list in our courtrooms. So I plead with my colleagues to see the need to give the support and let this House rise in unison to make sure that just like we as politicians has benefited by way of the time frame for electoral matters, let us have the common litigants, let us have the common citizens of Nigeria benefit the same way we in the political class have benefited by way of election petition. So on this note, Mr. Speaker, I plead with my colleagues to support this bill, that let it be read the second time, and I so submit, Mr. Speaker.
Heading the Constitutional Review Committee, and he will know how to handle that matter. So I think we'll just put the question. Those in support, please say aye. Those against, please say nay. Ayes have it. Matter referred to. Second reading, sorry.
Of the Federal Republic of Nigeria, 1999, to set time within which civil and criminal causes and matters are heard and determined at trials and appellate courts, in order to eliminate unnecessary delay in justice administration and delivery, and for related matters. Second reading.